A putative spouse is one who unknowingly enters into a legally invalid marriage, believing in good faith that he or she is entering into a valid marriage. Common examples of putative marriages arise when an individual marries a second spouse without fully divorcing the first spouse. The 2013 case of Ceja versus Rudolph and Sletten Incorporated examines one such scenario in California, a state recognizing community property and other rights of putative spouses. When Nancy met Robert Ceja in 1999, he told her he was separated from his wife. In 2001, Robert filed for divorce and began living with Nancy, and the two decided to marry. On their marriage license, which was signed by both, Robert falsely indicated that he had no previous marriages. In 2003, Nancy and Robert got married in a well-attended ceremony. Thereafter, Nancy changed her last name to Ceja and held herself out as Robert's wife. The couple wore wedding rings, lived together as husband and wife, and had a joint checking account. However, Robert's divorce hadn't been finalized at the time of his marriage ceremony with Nancy. 2 months after the ceremony, divorce papers were sent to Robert. Nancy sent these same papers to Robert's labor union to have her added to his insurance. The two carried on as husband and wife until Robert died on the job at a construction site. Nancy brought a wrongful death action in trial court as a putative spouse against Robert's employer, Rudolph and Sletten. Rudolph moved for summary judgment, claiming Nancy didn't have standing as a putative spouse because she failed to meet the good faith requirement. Applying an objective test for this requirement, the court granted Rudolph's motion. The appellate court reversed, ruling that the good faith belief required for putative spouse status turns on the relevant party's subjective state of mind. Rudolph petitioned the California Supreme Court, which agreed to review the case.